What's going on, Limitless Legion? So today we're going to be reviewing a case of a tenant who has subsidized housing for $58 a month. Yes, $58 a month. And she's in court today, and they're trying to evict her because apparently she's late on her rent month after month after month. So if you know anything about subsidized housing, with that eviction, she may never be able to get it again. So without further ado, let's just hop right in.
Number is 252-356. Let me make my note. Mr. Artley is here.
And Judge, Ms. Sanders did contact our office. She spoke with our intake attorney at the beginning of the week. Case was assigned to me yesterday, and although we normally wait to speak to the client before presenting through case review, I did present it through case review yesterday, and the decision was that we should appear on behalf of Ms. Sanders as attorney of record.
All right.
Sorry, Tara.
All right. You have represented her in the past.
Hold on.
This is originally filed. We were here on December 5th. Parties were put in a breakout room and talked at some considerable length. This was filed as a termination of tenancy. The defendant is habitually late on her rent, and the plaintiff simply wants to terminate the tenancy. She's been there for some time. We had some struggles with her kids and with her, and this is the second hearing in the matter. Mr. Fleeman, what's the position of the plaintiff?
Your Honor, the plaintiff's position has not changed. They still are seeking possession of the unit, but I have not had any further discussions with Ms. Sanders or with Ms. Bauer, obviously, because she just got involved. I will say for the record, and I presume the court record reflects this, but I don't know if Meg would know this yet. I did file an amended complaint to reflect that prior civil action, because after our first hearing, it occurred to me that I had not indicated there was that prior action. So just a housekeeping matter.
Yes, I did. I read it, and the clerk had noted that it had been filed. So, Ms. Bauer, what's your position?
Okay. My understanding is that the defendant's rent is currently paid in full and potentially with credit on the account. That Ms. Sanders is a client of Pivotal, and that this is not doesn't warrant possession for the plaintiff. There is a de minimis harm here, and an effort to go out of their way to make someone homeless when we don't need that right now. They haven't expressed a significant harm as a result of the payments being late, and whether there's a need to request an accommodation or not. In light of the relationship with Pivotal, I would need to investigate that further, but believe it's a possibility. Also understanding that I have not had a conversation with Mr. Fleeman, and I'm only relying on what I can read from the pleadings and our notes from the conversation with Ms. Sanders.
Yes. So they wish to terminate the tenancy. You get contacted by the defendant. This isn't your fault. You show up today and say, oh, by the way, I'm appearing, and here's a couple of potential defenses. And so she's habitually late on her rent, and apparently they're tired of it. On or about January 2nd, a default was entered. Conditional dismissal was issued as rent was not paid. March 12th, a conditional dismissal was issued granting another stay of the terms of the agreement. Rent was not paid. January 13th, a demand for possession, non-payment of rent. February 11th, demand for non-possession, non-payment of rent. March 11th, demand for possession, non-payment of rent. May 13th, demand for possession, non-payment of rent.
Judge, may I address these?
I'm not done yet.
Sorry, I thought you were.
May 13th, conditional delinquency. June 11th, demand for possession, non-payment of rent. Met with management counseling regarding payment. On or about August 12th, demand for possession, non-payment of rent. So that's what long history triggered all this, over and above the other issues. So Mr. Fleeman or Mr. Artley, do you concede that is rent current?
I do not know, because in a termination case, I don't normally ask for a ledger.
Yeah, once you file a termination, you can't accept any rent. So the notice to quit was filed in October sometime. So we probably don't have October, November, or December's rent paid.
Judge, my understanding is that she has a credit on her account right now.
Yeah, her rent is up to par right now.
All right.
Also, Judge, with regard to...
Here's my thing, right? Because we have all this history to show that month after month, you're late on your rent, and your rent is extremely cheap. I don't even know if you could use the word cheap. Like, it's nothing, basically. And you're late month after month after month. But now all of a sudden everything's up to date. So what that tells me and indicates, because he was able to literally list off every month, what that indicates to me is that things only get paid when they take certain action, and then you end up in these dire circumstances to where you know that you have the potential to lose everything. So that tells me that you have the money, but then you're sitting on it until they actually decide to do something about it. And then we're wondering why they're deciding to evict you when you've been there so long. It's because they know your situation and they know that they can get another tenant tomorrow. But what they don't want to have to deal with, right, is having to file these proceedings, having to come to court, having to get representation. All those things have ancillary costs associated with it. And like I said, they can go and find somebody else tomorrow that will be happy to be the perfect tenant and pay $50 a month.
To the first conditional dismissal you mentioned, that was actually scheduled for a hearing with you. You cited in favor of the defendant. Attorney Fleeman and I proceeded to further negotiations, and that resulted in the March settlement. So the allegations in 16 and 17 are only a part of the picture.
And Your Honor, that is correct, that there was a second conditional dismissal. I don't believe that we negotiated for that one. I think that was as a result of a hearing, but I could be wrong in my recollection. But in as much as that case was dismissed and stayed dismissed, then the prior violations are fair game for this case as well, which is why I did the amended pleading, is that to let the court know that yes, so that continual delinquency stretches all the way back to 2022. And I would also say for the record that the specific federal regulations for rural development spell out, material noncompliance and other good cause. But one of the few things they actually spell out specifically is continual delinquency.
Judge, if this is related to my client, I object to it appearing. I don't know.
Oh, just a minute. Miss Blanquette, you've stolen my screen. Or Mr. Lewis Blanquette, you're screen sharing your screen, and I'm not sure how you hijacked it.
Yeah, I didn't
But
think
I'm going to remove you. All right. So we have the rock and the hard place. Defendant doesn't wish to move. She is a client and may be entitled to some accommodation. The landlord has reached the end of their rope, filed this action. She now has representation. You didn't say it, but are you asking for a stay or a continuation of this?
I did not. I suppose conceivably there could be a Park Forest situation that would warrant a dismissal right now. However, I don't think it's in Ms. Sanders' interests to have another case filed against her. So I would ask for an adjournment so that Mr. Fleeman and I can.
Why would she be entitled to a dismissal right now?
If her rent is paid in full with a credit, then.
But this is filed as a termination of tenancy, not a demand for non-payment of rent.
So unless the last payment that brought her in full preceded the notice to quit, then there would be receipt of rent subsequent.
All right, I got you. So you're contending that the plaintiff has accepted rent after filing a termination of tenancy.
That is correct, understanding that I have not myself seen the ledger. But Mr. Artley did represent to the court that her rent is current through today.
And Your Honor, I believe there is language in the notice to quit, though I'm not able, or the attachment to the notice to quit, though I haven't put my finger on it yet, that specifically addresses the Park Forest issue by stating that any rent payments received after this date will not serve to waive or bar plaintiff's notice to quit. That would be in a case that came subsequent to Park Forest. Bray versus Smith, I think. Something versus Bray, maybe.
As an officer of the court, the case he is thinking of is Aspen.
That's it.
I don't know the full citation. There are exceptions to that decision as well. At page 6.
Here's what I ultimately want to understand. What I really want to hear is like an explanation, because you've got one side trying to argue that they just want to be done with her, and then you got the other side trying to defend it. But what we're missing in the middle is, why is this happening? Why has this been happening for so long? And what's getting in the way of you being able to pay minuscule rent and not end up delinquent? And what is ultimately going to be our guarantee that this isn't going to happen again? So hopefully they actually speak to the plaintiff, or the defendant, and we kind of get her side of things.
6. I don't recall seeing that when I looked at this last night, but it is 7 or 8 pages. So
Right.
All right, well, you're not asking me to dismiss the case at any rate, so, and there's no need for an escrow order because her rent is current. I could do an escrow order for January. How much is the monthly rent?
Daniel, I'm gonna relate.
58.
Judge, can I confirm with Ms. Sanders that that's accurate? I thought it was 26.
Ms. Sanders, how much do you believe your monthly rent is?
Right now it is 58, but when I last went to court, it was supposed to be 26, but it never was 26. I ended up paying 58 from then all up
26? What? That's crazy.
until now. And I just got a new sign in saying as of January, my rent dropped down to 34.
Y'all really put that into perspective. Imagine you're already getting cheap rent, $58, and then you get over 100% discount, and it literally gets cut in half to 26. To add insult to injury, 26 plus 26 is 52. So that's still not even 58. You're already, wow. Let's keep going.
And so I am currently paid for this month and half of next month already.
All right, well, there's no need for an escrow order. Everybody who wishes their rent was $58 a month, raise your hand. This has got big consequences. You're not going to ever find a place, certainly not as nice as this, but any place for $58 a month. For reasons I don't understand, you're late month after month after month after month, which I think may have to do with carrying forward past arrearages. Now your rent is paid in full. They wish to terminate your tenancy. We've got this issue about acceptance of payment after termination of tenancy has been filed. Mr. Fleeman alleges there's some sort of exception in the lease that I haven't looked at. And Ms. Bauer's here to profess your defenses. For the complex, it's like, well, we got rid of Ms. Sanders and there's somebody waiting to move in. For you, it's like you're homeless. You're unable to get other subsidized housing because you got evicted from this place. And so it's a lot more consequence to you than it is to the plaintiff. But whatever you've done has irritated them enough that they wish you to move out. So I'm going to set this into the future, and I'm not going to do an escrow order because the rent is minimal and she claims much of it has already been paid.
But here's what a lot of people don't want to talk about when it comes to this. There is going to be a low level degree of jealousy with everybody you deal with when you're getting $26 rent. So I say that to say, man, you better be the perfect tenant. You better be, when I tell you cutting the grass, you better be taking care of everything, keeping it pristine, have a great attitude, be happy, be pleasant. Because you see right here, the judge said, I don't know what you did, but they want you gone. Because honestly, I'm a little jealous. So even though the landlord is somewhat profiting, it's still like, man, you're getting taken care of. you're getting 20. Like I couldn't even fathom getting rent that low and then having a nice home to be in. Sounds like she's in the house. So you need to like seem grateful, and you dang sure can't be paying late, because then people are gonna kind of stand on their principles and be like, you know what? We forget the fact that there are people who will go out of their way in order to like mess up other people's lives. So if you're actually actively doing something that's inconveniencing the landlord who was just trying to, put her investment property up for rent, and then she just wants to kind of set it and forget it. But now she has to show up to court and all this. Like, nobody's gonna, don't nobody got time for that. When you have such small responsibilities to ultimately have to bear on your own. So we'll leave it there. That was a good one. That was an interesting one. We'll review more of these. Y'all like the video, also subscribe if you want to join the Limitless Legion. Cash App link below if you want to buy your boy iced coffee, tip the channel. And also feel free to join the Patreon as well, where I post self-improvement content. Until then, I'll catch you in the next video.